We're back on record in the matter of Gregory Martin, 24PR00777. I believe we left off with direct examination of Ms. Fuller. Ms. Fuller, you can retake this stand. You're still under oath from this morning. Everybody's back. Ms. Salisbury, go ahead.
Thank you, Your Honor. Ms. Fuller, I think we left off somewhere around some questions regarding your findings, regarding your review of the financial documents for the protected person. I believe you answered that question, so we'll jump down.
Objection. I'm just trying to state something.
There's no question before the court. There's nothing to object to, Mr. Lee. Go ahead.
What kind of concerns in general do you have that you, going through the last 4 months being the temporary conservator and guardian?
It's kind of gone into two different places. The first one was the financial concerns. After reviewing the financial statements, there was those huge concerns like how are we going to pay for the medical, how are we going to pay for his care, how are we going to pay for housing. We got Medicaid on board, so that's been, that concern has been taken care of. The next concern now is medical. How do I keep him safe? How do I keep him happy in a place? How do I make sure that he has the one-on-one care that I feel like he could need? And so that's our next concern.
Okay. And have you been working with the VA to schedule out and plan kind of what you'll be doing for his care?
Yes. Yeah, we've been working with different placements, whether it be a long-term care facility or more of a foster home where you have a lot less people and more one-on-one, which is kind of, I believe, what we're leaning towards.
Okay. And let's see. There were some questions regarding your LLC license for the Secretary of State. You want to talk a little bit about that?
Sure. It was after, actually, Mr. Rashid did notify us that our licensing wasn't up to date. After looking at it, it found out that it was mailed to my previous housing, which I sold, and it just flipped our radar. So once we restated that, they reinstated it with no problem.
Okay. And so as of this point, you guys are an active LLC. Your Honor, I would request that the court take judicial notice of ORS 63.654. I'm happy to go over that if you would like me to.
Sure, go ahead.
This is specifically about the LLC statute, and it discusses what happens with the Secretary of State if the Secretary of State administratively dissolves the company. And so under subsection 3, it says when effective, the receiver...
So I think, here's what I'll do. I'll take judicial notice of the law, just like Mr. Lee, but I think what you're doing now is argument for closing, so you can make your argument at that time.
Certainly, absolutely.
Go ahead.
Okay. Ms. Fuller, is it your understanding that when you reinstated your standing as Secretary of State, that it related back to your date of when it was dissolved?
Yes, I believe I was told that once you repay your payment, that they reissue it as if there was no lapse in there.
Okay. Thank you. There's another question about your workers' comp insurance. Can you explain a little bit of that?
Another thing that was brought to our attention, however, after calling the workers' comp, my colleague calling the workers' comp, we don't have employees. We are the owners of the company. We are not required to have workers' comp insurance.
And in the petition for the guardianship and conservatorship, are you and Ms. Fospak appointed individually?
Yes. I believe that kind of hit home with Lane County, from Lane County more, is that when a fiduciary does bad, they want to nail the fiduciary. And so the courts will appoint a fiduciary and not a company. It's also harder to get a company bonded, and so when you take these conservatorships, you want to do the fiduciary themselves so that you can make sure they're credible, they're bondable. And so, yes, court cases are appointed to a fiduciary, not a company.
Meaning that if you chose to leave Oregon Advocates, it's not tied to this case.
Correct. So when I left Avanti, my court cases went with me because they were appointed to me.
And speaking of bond, have you ever had a claim against your bond?
No.
Have your court fees ever been challenged when requested for approval at court?
No.
Have you ever had a guardian's report objected to?
No.
Have you ever had it challenged?
No.
In the Morningstar matter, the judge referenced that you had breached a financial duty. Was your bond, a claim against your bond at that time?
No.
And with licensing, can you explain a little bit of what your licensing looks like?
Personal licensing or business licensing?
Fiduciary licensing.
Fiduciary licensing, we are required to recertify our fiduciary license every 2 years. We are required to do continuing education credits up to 20 or 25 plus. We are required to be certified through the General Guardianship Association. And then I choose to also be a member and participate with the Oregon Association as well.
And since, at any time, has your licensing been denied?
No.
And that includes after Morningstar?
That includes after Morningstar, and it also includes any federal backgrounds that I do for the military, as well as my national dementia practitioner certifications and requirements.
Okay. And jumping on the other side of this case, currently, do you know what the value of the bank account held by Mr. Martin is?
I would say when those records were subpoenaed by Adult Protective Services, who once we got involved handed those over to us. At one point when I believe Dawn relinquished her authority, they were at $197,000. By the time it came to us in April, we are down to $34,000.
$34,000?
Correct.
And
Which have been frozen.
who froze those?
Adult Protective Services worked with the bank, and the bank has frozen them.
Okay. Have you had access to those yet?
I have not. Banks do not give access to temporaries. They only do it to permanents.
And in the cases that you've been appointed by for Judge Henry in Multnomah County, ever any limitations on those cases?
No, but I'm happy for any restrictions that would make the court more comfortable.
Okay. Any other judges ever put any restrictions?
No. Shortly after the Morningstar, Judge Holland did have that audit to be done. I want to say that was 6 months to a year after the Morningstar by Guardian Partners. Ever since that came back, there was no other restrictions or checks or any of that.
Okay. And what actions have you taken on behalf of the protected person as either the guardian or the conservator?
Well, we go and visit him. Because of concerns and discussions of elopement, it was discussed with the care team to do I believe it's a HIPAA protective order, which all it means is that you have to know that the person is in the hospital, and you have to go and ask the head charge nurse who or where this person is for them to be able to show you where he's at if you don't already know what room he's in. Other than that, we applied for Medicaid. We got Medicaid approved. Despite him having a tiny amount of finances, we worked on placement, but that's still pending.
Okay. And were there ever any unusual interactions that happened at the hospital on the weekend?
There was. I received some documents and they were asked for me to deliver them to the protected person. I managed to make it to Portland. I saw 2 clients before I became very ill. Rather than continue to go see Mr. Martin, I decided to come home and not spread whatever illness I had. I arranged for those papers to be delivered to the protected person. And then I was also notified that a person in a white coat had been visited with the protected person with the purpose of doing a paternity test. When asked, and this was coming from the hospital social worker, when I asked what that was about, no one knew. It was not authorized, nor was it discussed prior to, nor did the protected person give, or was able to give authority to allow that type of a testing to come into a hospital setting. So that was concerning.
Okay. To your knowledge, do you know how much is required for a conservator, the minimum amount that's required for a conservatorship?
I believe less than 10,000. I think 10,000 is your cap for conservatorship.
Cap or?
Or less, it needs to be more than 10,000. I'm sorry, more than 10,000.
Okay. And when you talked about the HIPAA protection waiver, was that something that a hospital implemented?
Yeah, I didn't know about it, but it was a recommendation by the hospital that we said that's probably a good idea at that point. And that came shortly after that person in the lab coat came in.
Yeah. Okay. And would you be willing to continue to serve in this matter as a guardian and conservator for Mr. Martin?
It's challenging, but yes.
Okay. Your Honor, are there any other questions at this time?
I have a question. You mentioned the bank account is $34,000, give or take. What about the value of the properties involved here?
So the value of the properties, the documentation that we found, it looked as if some signatures were deeded over, deeding the properties over to Selena.
Okay. We need to circle back to the conservator bond issue if it becomes relative. But for now, Mr. Rudolph, do you have any questions?
Yes, thank you, Your Honor. Good afternoon, Ms. Fuller.
Hi.
Can you describe your interactions, your personal interactions with Mr. Martin?
For the protected person?
Yes.
I visited 3 times, and all 3 times, the first time he opened his eyes shortly and then closed his eyes and would not engage. The second 2 times he refused to open his eyes.
So, is it fair to say that he has not communicated with you at all?
Correct.
If you're appointed as guardian conservator, how would you go about making decisions on his behalf, given that he's completely unable or unwilling to communicate with you?
So we do, it's kind of a tri-level answer. First thing we always do is talk with the protected person. Just because they can't answer you doesn't mean they're not there. So I'm going to go in, I'm going to talk to them, I'm going to, discuss what the plans are, wait for maybe some sort of reaction. If and when there are no reactions, our next thing is I like to bring in the counsel. Because you guys represent your clients. I want you guys on board so that you know what is in the best interest for your clients, what next steps are so there's no questions. I also like to bring in the family because it's their family, it's their loved ones, and I want everyone on the same page. If we can't come up with a decision, then I'm gonna try and use the least restrictive means, but what would he have done? Could he have made those decisions? And then make the decision off of that. If I still feel like there's gonna be some contentiousness, then I'm gonna ask for a court order for direction.
And this is a situation where there's obviously some disagreement amongst the family members, correct?
Correct.
And so in this type of a situation, how do you handle the difficult family dynamics?
So for this one, I'm gonna start off with, I'm gonna work with social worker, and I'm gonna find some sort of place that I feel is placement that is appropriate for him. At this point, I don't believe that there is a unanimous family agreement that they can be. So I'm probably gonna notify the courts, ask for a letter of instructions with my plans. In other words, the plan would be to move him to this place, should the judge agree. I'm going to notify the family, but again, my thoughts are they may not all agree, and then put it back on the judge so that I have that court order approving a move and approving the location of the move.
And there's been discussion about the Morningstar cases and other cases where statutory requirements haven't been strictly followed. Are you confident that your current attorneys are properly advising you on your legal obligations?
I sure hope so. And I would say fiduciaries don't have access like the attorneys do to be able to do pleadings and follow them as closely as I feel like they should be. So it's important to have a good legal team to be able to advise you and guide you. It's kind of like a marriage, it's a partnership. You gotta give and take. So yes, I do feel now that I have a great attorney team.
And if appointed, would you follow all orders of the court?
Absolutely.
As it relates to the guardianship, what are the most important issues that need to be addressed immediately?
I'm told he's stable for discharge, so the immediate things are placement. Let's get him out of somewhere that is a cootie controlled place. Let's put him in somewhere that's a lot safer and healthier for him. I want to get him back on some sort of like physical therapy, because just sitting in a bed for months and months, he's just deteriorating. And I feel like if we get him into maybe a foster home where they're one-on-one, that will help with some of his mobility. He's not going to get up and run, but at least he won't deteriorate as much. That's step one. Step two is the counter stuff, everything that's being filed. And then we have the third part, which is the financial issues, and there's a whole lot of mess that needs to be dealt with as far as regaining the finances that we're taking, regaining the properties that we're taking.
Objection.
Overruled.
Okay. Regarding the financial assets, you said that prior to your appointment, you reviewed documents showing that he had $197,000
Correct.
in financial assets.
In a bank account, correct?
And you mentioned that currently he has around $34,000,
Correct.
and that's in a frozen account.
Correct. And that was last as of April of 2024.
Okay. And so, at what point of time did he have the $197,000?
July of 2023.
So between July of 2023 and April of 2024, the account went from $197,000 to $34,000.
Correct.
And have you been able to review and trace where the funds went?
I show them as ATM withdrawals, some daily, if not sometimes multiple times a day. And I show furniture payments to MOS Furniture. But the majority, 98% of them are ATM withdrawals.
And was money being withdrawn out of the ATM during a period of time where Mr. Martin was incapacitated
And in the hospital,
and in
yes.
the hospital? Do you have any idea at this point who was transacting on those accounts?
It would be my assumption that it was Selena. as she was the
Objection.
only-
Sustain.
If appointed as conservator, would you take steps to try to ascertain who was withdrawing the money from those accounts?
Absolutely.
And if appropriate, based on consultation with your attorneys, would you pursue claims on Mr. Martin's behalf to recover any wrongfully taken funds?
Absolutely.
You mentioned that Mr. Martin is on Medicaid.
Correct.
Can you explain how he was able to be qualified on Medicaid, given that he appears to have some assets that would possibly put him over the limit?
I will say it took an act to get him qualified because technically by deeding certain properties away, that is considered a disqualifying act. You are no longer eligible. It looks as if you are giving away assets.
Objection.
Basis.
Basis is hearsay. She does not know what Mr. Martin's capacity was at that time.
Okay, I don't think that's what he's asking. It's overruled. You can answer.
We were still able to have them overlook that. Being Medicaid's other guidelines are financial. You need to have less than $2,000 to be financially eligible. Being that his assets are frozen and not in his care, we were able to overlook that as well, making him eligible for long-term care Medicaid and placement for housing.
Have you, in the process of your role as professional fiduciary, qualified other clients for Medicaid?
Yes.
And would you describe this situation as unique in that you're attempting to qualify somebody for Medicaid who appears, at least on paper, to be disqualified?
Correct.
Do you have a sense at this point about what Medicaid is picking up as far as, you know, the amount of their benefits they're paying on his behalf?
I don't know.
Okay.
I can tell you a long-term care placement right now is running between $7,000 and $15,000 a month. If you have any source of income, so say you have Social Security or PERS, retirement or VA or something like that, you are to pay X amount of money minus what they consider your personal incidental funds, which equals, depending on where you're at, about $175 is what you're allowed to keep per month. Everything else gets paid towards your care.
And so if assets are recovered and his account is unfrozen, it is likely, given your experience, that he would then be disqualified from Medicaid.
So the money that is in the account is going to be used for legal fees. The rest will be used for to pay for his medical placement, hospital bed. He's been in a hospital gown for some time, so I'm assuming he's going to need some clothing, some shoes. So we'll use that money to make sure that he is set up comfortably. Normally at that point, that exhausts that. If by chance that we are able to recover any assets that are no longer available at the second, then it's no fault to go off of Medicaid during that time and do what's called a spend down. So we would use the money just to pay for whatever necessities he has, including his medical care, until that's spend down, and then we would reapply for Medicaid at that time.
How many properties did Mr. Martin own prior to these transfers that you referenced?
I believe we did a less pendants on 6 properties. That somewhere around between 5 and 7, I believe.
Objection.
Overruled.
And based on your review of the property records, Mr. Martin is no longer the his name no longer appears on the title of those properties.
Correct.
Based on your review of the finances, did he receive any consideration for those transfers?
No.
If Mr. Martin regains the ability to communicate his wishes and desires, would you listen to his input?
Absolutely.
And would you update the court on any changes in his condition?
Absolutely. I believe we are statutorily required to not only provide annual notices to the court for our reporting, but if there is any special circumstances or extenuating circumstances, I always provide an interim report to the courts to let them know of something that's going on.
You're willing to serve as the indefinite guardian and conservator for Mr. Martin?
Yes.
And you're willing to do that at this point, even though there's an open question as to whether you're going to be able to recover any assets on his behalf?
Correct. And I will also just state that fiduciaries do not get paid on a monthly basis for our cases. We don't get paid until an annual basis when the court approves our fees. So yes, we take these cases on even knowing that we may not get paid. We do it pro bono.
No further questions.
All right, Mr. Billy, go ahead.
Have you ever been found by any court as a guardian to have breached your duties regarding your general welfare of the client?
Yes.
Have you ever breached your financial duties to the client?
Yes.
Have you ever been considered abuse allegations during an investigation?
I think I need a little more clarification.
In the Morningstar case, was there an abuse investigation concerning the welfare of your client?
I believe that's what I was removed from.
In that same case, was there allegations that 37 home visits that you billed for were discovered to be correct or incorrect?
It was discovered during that time that I needed to provide additional documentation, which is what we put into place with our practices now.
Do you bill for telephone calls to care facilities or attending care conferences or medical appointments part of your?
Yes.
Okay. In the Morningstar case, were you found to not have billed for these particular issues that were not proven to be true?
I will say that is why we put more practices in place so that I have proper documentation to show why I'm there, what I'm there for, and that I've been there. Because I did not have that type of documentation in order to provide that. Therefore, I didn't have my supporting evidence.
So that means
Mr.
those.
Billy, one second, I just want to ask a follow-up question. So are you saying that you did the work that you billed for, it's just you didn't have the right documentation?
Correct.
Okay, all right, Mr. Billy, go ahead.
And my funds my guardian's report was never challenged by Judge Holland. She approved all my fees.
Well, speaking of Judge Holland, let's get right to it. Judge Holland in Lane County. Stated that Mrs. Fuller was removed as guardian of Patricia Morningstar. Is that correct?
Correct.
And that your power of attorney was revoked. Is that correct?
The same case. Yes.
Did the court review all of your exhibits and heard witness testimony regarding those allegations of the 37 home visits? Were they judged that you did not make those 37 home visits?
I don't understand the question.
Let me clear it up. Did you make the 37 home visits in the Morningstar case?
Yes.
Were they proven to be accurate?
No, and that is why we now have documentation
That's what I
to
want.
clarify.
Okay, so they weren't proven to be. Okay, let's move along here. Is it one of your fiduciary responsibilities when you're filing a petition for appointment of the guardian? Is it fair to say that you're supposed to disclose certain information concerning past or prior removals as guardian?
Correct.
Have you had more than the Morningstar case? Have you had numerous cases or more than one where you did not disclose that information?
I believe I testified to this earlier.
That's not what I'm asking.
Mr. Whitley, you can answer the question as Fuller.
Yes.
In what county was the Tremaine case?
Lane.
Lane County. In what county was the Adams case?
Lane.
In what county was the Wheeler case?
I have multiple Miller cases.
Okay, I'm talking about the case number April of 2023.
I don't recall what county. I'm sorry.
In what county was the Larimer case?
That was multiple counties. I believe it started in Salem, and by the time that he passed away, he was in Bend, I believe.
Well, in that Larimer case, it was February of 2023. That rings a bell. Is that what county that it was in? I'm just trying to find out what county it was in. There's multiple.
I don't recall.
Okay, well, in that particular case, Larimer, was it that you did work, I don't know, was the word discipline or whatever, did you disclose information that you were not removed as a fiduciary in that case?
I disclose it in all of my professional fiduciary disclosures.
So in the Wheeler case, was that the same thing?
I do disclose it in all of my professional fiduciary disclosures. I believe what is cited is that the council, the petitioning council, did not disclose it in their petition. I didn't have control over what the petitioners disclosed at that point. So I do a professional fiduciary disclosure to help answer and fill in any blanks that the petitioner may have mistaken or didn't get correct or just didn't accurately put.
Let me trim this up a little bit. You are aware of the report about your fiduciary responsibilities or conduct in the consultation report done. Looks like it was January the 4th of 2024 this year. Are you familiar with that report? This is what I'm getting this information from.
Correct.
Yes?
Correct.
Okay, thank you. There seems to be a pattern of how words are being stated.
Your Honor, objection, testimony, not a question.
Your Honor,
Well, if you could get to the question.
yes. Did you state that you've been removed as guardian of a guardianship, case number 24PR00777, citing that the determination, specific as to the determination that the removal was absent of factual findings for that Morningstar case?
I don't understand the question.
Are you stating in these multiple guardian conservators, according to this report, that you have a habit of stating certain things but saying that they're not actual fact findings without further clarification from the court? Were you cited or warned by this counsel for doing this in multiple cases in the report?
I don't believe that that's correct. The CAP report was done as an audit base on all of my cases. It was found by the CAP report auditor that on the cases prior to the Morningstar case, that there was a statute that my legal counsel needed to provide notice to my current cases that I had been removed by this case, and that did not get done.
Why didn't it get done?
A, I did not know that that was done, and my counsel did not advise me that that needed to be done.
So you can say you're blaming your counsel?
No, I will take full responsibility.
Well, it states here in this report on multiple occasions that you use the same process in determining what you wanted to share with anyone receiving the petition, which means that would be the court. And I've asked you, what was the county of Bates? What was Bates? What county was that in?
I don't recall.
What county was Michelle, Mischel in?
Clackamas.
Thank you. What county was the Aspergillus in?
Multnomah.
And what county was the Brinkerhoff in?
Multnomah.
And what county was the Copenhagen?
I lied. Brinkerhoff is not. Multnomah is. It's the coast. I don't recall the county though.
What county was the Brown case in?
I don't recall.
Okay, and I'm talking about Marcia Marie Brown.
I believe that's Multnomah.
Okay. Are you familiar with the letter that was written in, looks like February the 28th, 2024, from the Clackamas County Courthouse regarding the guardianship of Holly Ryman?
Yes.
Can you describe that situation? And Thomas Steenson was on that particular case with you. Can you describe what this letter might be about to the court?
Mr. Stenson felt that the protected person should have legal counsel, and that was the basis of the letter, of which Mr. Martin now has.
So you didn't have legal counsel in this Clackamas County case?
Mr. Martin.
Are you saying something I'm missing? It says Clackamas County. What does Mr. Martin have to do with Clackamas County?
Mr. Stenson wrote the letter to the courts with his recommendations that the protected person, Mr. Martin, should have legal counsel to protect him.
Okay. Did he have counsel at that time?
It was uncertain. I believe the words on record were, it was complicated.
And this case is in February of 2024.
Hold on. I think we're talking about two different cases. Let me just make sure we're all in the same ballpark here, because I think we're in opposite coasts right now. I think, Ms. Fuller, you're talking about a letter written to the court about this case, correct? Mr. Reed, you're talking about a letter, I think you're referring to one by Judge Norby in Clackamas County on a case from February. Is that what you're referring to?
In the matter of Ryman, yes.
And you're referring to a letter, I think, issued by the court, Judge Norby in that case?
In February of 2024.
All right, so let's talk about, we're not talking about, we're talking about Clackamas County. So I'm just clearing it up for everybody.
Thank you.
So, Mr. Reed, you know which ballpark we're in now.
Okay, so
Okay.
All right, go
just
ahead.
to clarify, you were referring to the letter written by Mr. Stenson
In
or
February,
the
yes.
letter written by Judge Norby?
Actually, both of their names, it looks like it was written by Judge Norby to Miss Bungie at Willamette Northwest, and to Tom Steenson, Disability Rights of Oregon, in February of 2028. So this had nothing to do with Mr. Martin.
No.
Okay, thank you. I'm just trying to ask that question. Okay, let's move on to the next case. When did you first receive information about my father, Gregory Martin Sr., and who from, and give us a time, month, date, or time of year that you received information about my father's.
I believe it was a couple days before I called you on your birthday, so that would have been April. I received the call from Adult Protective Services stating that there was a protected person that was incapacitated that needed some assistance, and would I go please evaluate the situation.
So are you stating that you didn't know anything about the case? We were told by Megan Huffman that she contacted you looking at a website and found your business name. We're just trying to find out around the time. She couldn't remember what time of year that was.
For emergency cases, and what this was considered emergency, it would have been within a day or two before we jump in. So it would have been the first part of April.
Okay. First part of April, we said the first, the second.
First part of April.
Is there any way to verify that?
I can pull out my notes.
Did you bring them to court today?
I can pull out my electronic note.
Your Honor, can we find that?
What's the date you're looking for again?
Well, the first date that she remembers being called on my father's case. We have another witness that stated they didn't know.
Remembers or she doesn't, so.
She said she did on her electronic notes.
Yeah, well, there's a process for that, under the evidence code to get that information out, but I can't give you legal advice.
I'll pill it. Okay, so around the 1st. So that would leave at least a few weeks before you filed your petition on April the 18th into the court regarding emergency petition. Is that correct?
I don't believe it was a few weeks, no. I believe it was definitely within 7 days.
Okay. And speaking of that particular petition, did you know that according to Oregon 63637, it's the it's the Oregon State Corporation, not corporation, but the Secretary of State's part of their rules that are written down in the ORS 63. And at that particular time, did you state for the record that your business was administratively dissolved or revoked by the Secretary of State for failure?
I was unaware of that until you pointed that out, so I thank you. And
Okay.
once it was pointed out, we paid for it and it was reinstated. And according to their rules, it is backdated, reinstated as if there was no loss of coverage.
Okay. Then that means you would know that for 8 months, was it 8 months or more that you were out of business? You forgot about your business license being revoked?
It was unpaid for, not revoked.
Well, that's the process. It's called being revoked.
Your Honor, objection, testifying, there's no question here, he's stating matters of law that he has no knowledge to.
I do. I have the record here, Your Honor. They were
Your Honor, there's
revoked.
a process for this.
So the objection is sustained.
Thank you, Your Honor.
Now is a good time to take a break.
Thank you, Your Honor.
Thank you.
We're going to be back in 15 minutes.
305.
And that objection is sustained. You can rephrase your question
Gotcha.
or ask your next question. Go off the record.
Okay.